Good afternoon and welcome to our webinar. Just a couple of housekeeping tips before we actually start the webinar. First, this webinar is being offered for one AMA PRA Category 1 credit, CME. At the end of the webinar, we will send you an email with a link to complete the evaluation, and your CME certificates will be emailed to you within approximately 10 business days. There are a couple of downloadable files in the lower left-hand corner. The first is a copy of today's presentation, and the second is a resource that we hope you'll find helpful. There is a open text polling suggestions for future webinars on the right-hand side of your screen. If you have any topics that you'd like to suggest for us, we're always looking for new topics and would be happy to have you give us some input. So let's get started with the webinar. Today's topic is medical care for minors. I'm Kathy Bryant. I am the manager of TMLT's Cyber Consulting Services. And joining me today is Cassie Turner, manager of TMLT Risk Management. We hope you enjoy the webinar. Just real quickly, our objectives are to help you understand and identify the rules and regulations in Texas for treating minors. This is one of our most frequently searched questions on our resource hub, as well as questions that come into our risk management department. We'll talk some about consent for treatment of minors, and we will talk about the regulations governing medical records retention. So when we think about medical care of minors and what are the laws surrounding it, one of the rules that comes to mind is the Texas Family Code. And in fact, a lot of our information today is based on Texas Family Code. However, the last slide of our presentation is a summary of a lot of different laws that come into play in special situations for caring for minors. And of course, Cassie and I couldn't do a webinar without talking about HIPAA, but just a little bit on the side. So with that, I'm going to let Cassie kick off our webinar.
Perfect. Thank you, Kathy. So just to get started, I'm sure most of you are aware, but we just include the definition of who is considered to be a minor in the state of Texas. So the definition is a minor is an individual under the age of 18 who has never been married and who has never been declared an adult by the court. Minors are deemed to be incompetent decision makers and therefore unable to make healthcare decisions or give informed consent on their own behalf without there are some exceptions as with everything, and we'll talk a little bit about those. So generally consent will fall to the parent or legal guardian in most situations. So, when can minors consent to treatment? This is a pretty robust list of exclusions of when they can. I know Kathy mentioned that there's a download there called the Adolescent Guide. I would encourage you to download that and keep it as a resource and also keep their link so you can check for any updates. That resource has been updated as of October of 2023, but it outlines these exceptions and a lot of the things that we're going to talk about today in a little bit more detail. So it's something that you could have on hand. We actually reference it quite a bit within our risk management department. As Kathy mentioned, we get a lot of questions on minors. So we do refer to that guide quite frequently and find it very helpful. So Minors who can consent, anyone that's on active duty with armed forces of the United States can consent. A minor who is 16 years of age or older, residing apart from his or her family, guardian, and also managing their own financial affairs. A minor who is unmarried and pregnant can consent to their own treatment other than abortion. As you all know, abortion has a lot of its own rules, and those we will not address in this presentation today. But just note that that's an exception. A minor can consent to diagnosis and treatment of infections, contagious diseases, communicable diseases that are reportable to the Texas Department State of Health Services. Reporting requirements don't change for minors. It's just as you would for any of the other um, reportings that are within those diseases. But again, they can get treatment for those without parental consent. Additionally, a minor who is unmarried and is the parent of a child and actually has custody of that child, making decisions for medical, dental, psychological, or surgical care for the child. So, just as long as they have that child within their custody, then they can continue consenting for their own treatment. A minor who's serving a term of confinement in a facility operated by or under contract with Texas Department of Criminal Justice can consent for treatment. And a minor can also consent to counseling for suicide prevention, chemical or alcohol addiction, dependency, or sexual, physical, or emotional abuse. Generally, a statement is recommended written as to the grounds as to why the minor has the ability or capacity to consent to their own treatment. Recommend documenting that, maintaining it in their medical record for future reference should you need it. So here, who can consent for the treatment of the child of an unmarried minor? And this gets a little bit wordy, seemingly, but an unmarried minor who has actual custody, as we mentioned, of their biological child and is consenting to their medical treatment, surgical, psychological, dental of that child, they can also consent for the treatment of that child, unless there is an outlying situation where they do not have custody. So that's the distinction they're making here. So if for some reason the child of the minor parent is in CPS or foster care, there are no other children that that unmarried minor is consenting for, then they would not have the ability to consent for their treatment. So that's the little bit of the distinction that they're making there as far as actual custody is concerned. So this question is a little tricky sometimes, and we do get this quite frequently in our risk department and when we are out doing practice reviews. What are my legal obligations when treating minors for contraception? Non prescription contraception, parental consent is not required for them to purchase any type of contraceptive, condom, to receive information about family planning. All of that can be done without parental consent, can be maintained confidential. Um, we do encourage you to have discussions with your minor patients to, include their parents, particularly if they're on their insurance plan. More than likely, parents are going to get an explanation of benefits. So having those, candid discussions with minor patients can sometimes help with these types of situations. Um, but again, there are some exceptions. So under state law, minors cannot consent for prescription contraceptives. If they are legally emancipated, they can. So that's the exception there. I will just mention for emancipation, I've heard some of our attorneys that we've worked with say that emancipation is rare. It doesn't often occur because it takes so much to meet the criteria. So if you do have a minor that you is saying that they're emancipated and they want to consent for their own treatment, they want the contraception prescription, it's reasonable to ask for proof of that. There will be a court order documenting that. So if you're concerned and you're not sure, then you can go ahead and verify if they are allowed to, make that decision for themselves and are in fact legally emancipated from their family.
So this is another one of those hot topics that, goodness, we've been getting questions about this as long as I've been associated with TMLT's risk management department. And that has to do with the treatment of children who whose parents are divorced. This first part is about who has the right to review their minor child's medical records. Generally speaking, both parents have the right to review their minor child's medical records. It would be fairly rare that the courts limited the access to one parent, but it is possible. And if you ever have a situation where a parent is saying, "Gosh, I am the sole conservator," or "I am the custodial parent," it is probably in your best interest to get a copy of, like, the front page, the page declaring the parent legal guardian or the sole guardian, and the judge's signature, and keep that in your files so that if there's ever a question that you denied the other parent access, then you have proof of what you're basing your decision on. And this, of course, is still a very hot topic with HIPAA as far as the right to access medical records. And in the case of minors, that would extend to the parents or the custodians. So either parent can give consent for emergency health care, including surgical procedures, in typical cases where there is not solo custody. Joint custodial parents may have all the rights associated with doing anything related to consent for medical services unless it's specifically limited by that divorce decree. Typically, non custodial parents usually have a right to consent to medical or dental care involving a surgical procedure, or do not have the right except in emergencies. And a non-parent sole managing conservator and legal guardian are essentially the same and have the same rights and duties as the parents. So during emergency situations, it is perfectly um, within your right, and you should not withhold treatment just waiting to get consent. So, in the case of an emergency, either parent may consent to medical treatment. In the case of emergency treatment to preserve life, the medical provider does not need to uh, obtain a consent from the parent or conservator. It's called presumed consent. And if um, if you are making an attempt, we hope you'll be documenting that as well to contact the patient. I'm sorry, not the patient, but the parent. After you've gotten the patient stabilized, then you should make every effort to contact the parent or the guardian. Make sure that you have processes in place for going back and making sure the documentation is complete of when you tried to make the calls, what the response was, that type of thing. And by all means, after the patient is stable, it's important to determine who the responsible party is and have a process to ensure that they are contacted and questions are answered about the care that you've already rendered.
So, when can a non parent consent to treatment of a minor? The Family Code 32.001 allows others to give others to be given the ability to consent. So there's quite a few of these, and again, it's a list, and it is within that adult health guidance booklet. So if you want to have a concise list, again, download that guy. It'll be very helpful to you. Grandparents, adult siblings, adult aunts and uncles, educational institution with written authorization, any adult who has actual care, control, and possession of the minor with a written authorization can provide consent of the minor. A court having jurisdiction over a suit pertaining to a parent child relationship. An adult responsible for the actual care, control, and possession of a child under the jurisdiction of a juvenile court system um, may consent. A peace offer who deems that care is needed may also bring a minor in for treatment. And for immunizations, a guardian or any person authorized under law or court order can consent for these. I do see that that was a question asked about immunization. So here's some additional guidance for you pertaining to immunizations. I know we get a lot of questions about immunizations and COVID vaccinations and what have you. And as Kathy's kind of gone through, one parent can consent typically for those types of situations. And as Kathy mentioned, it's always good to document these things in the chart. If you do have someone that is a non parent consenting, if you do not have that written authorization, then try to verify. Even if you can't get in touch with the parent, at least make an attempt to see, is it okay for this person to be with the child? If they haven't given you any advance notice, something that sometimes is helpful is to encourage patients when you have them come for maybe their first initial visit or even at follow-up visits, encouraging them to notify you if there ever is going to be a time when they're not going to be accompanying their minor patient with you, just so that you have a better idea who is, consenting for that treatment of that child and documenting that into the chart. So, as we mentioned, delegation can be done in some situations. It is a formal authorization agreement that could be made with a grandparent, an adult sibling, adult aunt or uncle, again, of the child, giving them the ability to consent for medical, dental, psychological, and surgical treatment, along with some other rights. Again, you can review these in the Texas Family Code 34 if you're interested in those or needing those. There are some specifics about what the consent form should include. So you will want to make sure that any agreement between a parent and a non-parent should be in writing. It should be signed by the parent or the conservator giving consent, and it should be given to the doctor, hospital, or medical facility that will be administering the treatment. So again, if you're going to have that, you'll want to make sure that this form includes these items. It would need to include the name of the minor, the name of one or both parents, as well as identifying which is the managing conservator, the name of the parent giving consent, as well as a specifying relationship to the child. Is it aunt, uncle? Is it adult brother, adult sister? And then a statement regarding the nature of the medical treatment that is authorized to be given. So it can be limited to certain things or certain treatments that will be outlined within that consent form that the parent can identify on that form. Again, save this to the chart, and you may even want to make a note in your system or your EHR using your tickler system if you have one that there's a unique situation regarding this particular minor with consent on file for a non-parent consent form.
So when a child turns 18, I guess they're not really a child at 18. When your patient turns 18, things change dramatically. There are some legal issues around the patient turning 18. And you may want to start thinking about these ahead of that change. When a patient turns 18, in Texas, that's the age of majority, and they assume the rights and responsibilities of adulthood. At that point, you as a physician or healthcare professional may not share information with the parent unless provisions are made to allow that access. So this actually came up uh, in a conversation with a neighbor a couple of years ago with me. Their child was still living at home. They had been uh, to a physician, had been referred out for imaging studies. The mom went by the office to get a copy of the results of the imaging studies and was told, "I'm sorry, but your son has turned 18. I need his consent to give you a copy of his medical records." Well, when she and I were having the conversation, she was quite exasperated that she was paying the bills and why wouldn't they give her a copy? Of course, I was quite elated that the practice actually was following the rules and said, you know, I give them kudos for doing the right thing. I know it's hard to believe from your perspective, but of course, there's ways to do that. Um, so, and this was a family practice situation, but if you are a pediatric clinic, you probably have a policy already in place about when you transition care to an adult practice. Um, if you don't, it may be something that you want to think about. But some of the things that you might think about if you're seeing a patient and they're 17, that you might want to begin having a conversation with the patient and their parent about that the parent's no longer going to have access to medical records. Now, some kids may say, "Great, I can tell you whatever I want." I don't know. But the others may say, "Well, why wouldn't I want them to have access?" So you just need to be aware that different people are going to react differently. But you can handle it in two different ways. You can have the now 18-year-old do or grant access to their parent as a personal representative, or they can, on a case by case basis, say, yes, it's okay for mom to get a copy of my MRI or whatever the particular medical record they would like. But you should always have a policy and procedure and do staff training on how to address parent concerns. Because just like my neighbor, she was not a real happy camper the day her access got denied. So, a couple of things kind of already mentioned, but as soon as you believe, or as soon as the child is old enough and responsible enough that they need to start understanding their medical, I think that word is issues, not ideas. Um, you can begin to give your child an opportunity to make their own appointments. The parent can. They need to learn about their medications. They can interact with and ask questions of their healthcare provider. And they should be able to talk about what their medical issues are. And you want to be sure, though, if this is a minor child, when it comes to making their own appointments, yes, they can make their own appointments, but we will definitely cover this. I have seen a couple of questions about seeing patients that are minors without parents present. But again, they can make the appointment, but they can't consent to their treatment at that point.
So, what are my responsibilities if I suspect abuse or neglect of a minor. For a minor, the Texas Family Code and Texas law requires professionals to make a report within 48 hours of first suspecting abuse or neglect or exploitation of children. These can be reports can be made to your local or state law enforcement agency or to the Department of Family and Protective Services. Um, if you're not sure of what the definition of abuse, neglect, or exploitation is, there is quite a long definition list on that Family Code, Section 261. I believe it's also referenced in my little famous adolescent health guide as well. But you'll want to, make sure that you're reporting those as appropriate, to the appropriate people. If you feel that it's a life threatening or emergency situation, call 911 or your local law enforcement immediately, and then make the report to DPS. You can always call the abuse hotline 24 hours, 7 days a week. The toll free number is there for your reference. If you wanted to make a report online for some reasons of anonymity, or you felt that it wasn't something that required immediate attention, you could use the website. I think the takeaway there is that if you're really concerned that some of these could be in a queue for 28 to 48 hours, so just keeping that in mind, if you're really concerned, that there's a window of time there that would be, concerning for the protection of the minor. So a couple of other additional thoughts, I guess, more from a practice management standpoint, kind of in line with how Kathy was talking about, preparing and your parents when their minors are becoming of age and transitioning to adulthood and their own consent of their own care. Couple of things to mention, medical triage advice, encouraging physicians to be a part of that process and guidance and input into which staff can actually provide advice, via the phone or via the portal messages, and having policies and procedures up to date and in place that outline those specific guidelines that are written for patient triage. Staff training when you have a new staff member. I know that this is particularly a struggle sometimes in the current environment because we are seeing a lot of turnover and getting new staff trained. But just keeping those, you know, administrative items in check because they could impact a claim, or if information is given to a patient or a minor, that's not correct, then obviously that could be a concern. And then again, documentation of the staff training that they've received it, and just documentation in general, as we always say in risk management. It's just something that is always going to be the key. Can never document too much, I don't believe. But I would recommend too, when you do have a non-parent, or even with a parent, I would recommend documenting who specifically. I know a lot of the EMR systems will allow a default of, minor accompanied by parent or guardian, and sometimes that is great that it's in there. I think if you could take it one step for more with a specific person, grandmother, sibling name of that person would be very helpful, particularly if you have a minor who's coming in with multiple non-parent consenters. It just would be helpful, I think, if there were a concern, to document that in the note on the day of their visit of who's with them. So, how long do you have to keep their medical records? This is from the Texas Medical Board rules. They outline in Chapter 165 the requirements. The primary one here is if a patient is younger than 18 years of age when last treated by the physician, the medical record shall be maintained by the physician until the age of 21, or for 7 years from the last date of treatment. So whichever time frame is longer. So you would have to look at their last appointment and then add the ages there to make sure you keep it for the appropriate amount of time, the 7 years, or till 21. Again, whichever is the longest one is what the requirement is for maintaining those records. And if you get a request for the release of records for a minor under the age of 18, a valid written consent must be signed by the parent or guardian. Exceptions would be a court emancipated minor, or a minor who is married. We've talked about some of those exclusions already. And as Kathy was mentioning, a patient 18 years or older, that would be that adult now. Their written valid consent for disclosure to meet the HIPAA individual access for medical records. It would be that 18-year-old or older at that point who would need to consent for the disclosure of their or the release of their medical records. And then I know Kathy had mentioned at the beginning of the presentation that we would include a resource of all of the laws that are referenced in the Texas Family Safety Codes. And here they are, so that you can reference them and just see how involved and how complex some of these topics are. And there are many exceptions, as we've noted throughout the presentation today. So if you have questions or you're not really sure, hopefully these resources can kind of help you get to where you need to be in figuring out, am I able to allow someone to consent, or can the minor consent, and get the particular situation and get some answers from these different resources.
So Cassie, I'll give you a quick minute to catch your breath since you did a little series there at the end. I would like to just start by thanking everyone for joining today. The Again, we'll have the CME. We'll send that link out for the evaluation after. Actually, it'll probably be tomorrow morning before that goes out. The downloads are still available. The suggestions for webinars are still open, and of course, questions. So the first question is a documented phone call or FaceTime call acceptable to achieve the consent of a parent? I Certainly a phone call is acceptable. Typically, you want to have two people witness that. So if the medical assistant and the physician both witness it and document who heard the parent consent, that's certainly acceptable. I would be leery to do FaceTime calls only because FaceTime is not HIPAA compliant.
Yeah, and Kathy, I would just add too, I'm not sure if this person was referring to the consent form for a non-parent. So if this is for a non-parent treatment situation, then you would want to have that consent form signed and meet the criteria that we outlined in the presentation. I don't remember, I'm not sure what they're asking here, but if it's the parent or non-parent on that one.
That's true. Um, Always in writing is always best. Can we treat a minor in the office with the parent on the phone if the parent is not physically in the office? So I'm thinking that this question is basically the patient comes in and they actually establish a phone call, like on a speakerphone, so the parent can hear the conversation. You want to, again, first get consent to treat and document that. And then also, I would just make a note that if you have a patient who is especially old enough to drive to the office themselves, that you just make a note that they are acknowledging that the phone call is being, or is actually a two-way conversation, becomes a three-way conversation. So just a little something different. But again, the consent is the main thing.
So I think you touched on this next question a little bit, Kathy, about using FaceTime during a call, and kind of cautioning on that due to it not being HIPAA compliant and protecting their personal health information.
Um, there's a, let's see. Some pediatric policies have a policy that parents can only access their children's records after 13 years old, after the patient allows it. They send a message to the child allowing a link being sent for the parents to have access to the information in the portal. Is this in tune with Texas law? Um, I'm not sure that that policy is necessarily in tune with Texas law. I am a bit more concerned about it with HIPAA because the individual right to access, which for minor children, so someone under 18, is extended to the parent or guardian by federal law. And this is the number one thing that we see the Office for Civil Rights at the federal level actually investigating and having fines and penalties against practices for is for not allowing the individual right. And Cassie, I'll defer to you if you've heard anything about a 13-year-old having the ability to consent to that sharing.
No, not a specific age like that. And I think, as you've already mentioned, because of the HIPAA extending to the parent, if they have appropriate rights for access, that would seem to create a barrier of access, which would be an issue. So I'm not familiar with anything that's around that age for access.
This is an interesting one that they have minor patients that are age 17 that are in their first year of college and the parents don't live in the same town. What kind of authorization do we need to treat them? I think that you would need to get the authorization um, on each individual visit, just letting the patient know that the patient is presenting. Now, there may be some exceptions to, like the university or college, um, if there's a on-campus clinic, there may be some exceptions, but that would be probably part of the the university's protocols, not HIPAA or Texas law.
Yeah, I think the takeaway there for everyone, as Kathy mentioned earlier, is that the minor can come in on their own and you can gather consent or call the parent, what have you. But when it comes to the treatment and discussing the treatment, the minor cannot actually consent to that. So there needs to be some kind of process in place where you're discussing that treatment with the parent. You've identified them as the parent and you're confident that they are who they say they are and they are consenting to that treatment at each appointment on behalf of the minor.
There is a question about, I'm guessing, a non pediatric specialist seeing patients uh, because there is not a pediatric specialist that sees that type of problem and they want to know about their malpractice covering it. I would say you would need to check with your underwriter. They can give you the best answer as far as what is covered. If a parent comes in with a minor on their first appointment and the minors, say the minor is 16 or 17 and can drive themselves to the appointment, can the parent give written authorization to be seen by themselves, or do they have to have a parent or adult with them? So my understanding is you would still need to get consent for each treatment. The parent would not have to physically be there. It could be on the phone. Um, but again, you cannot legally prescribe to a 16-year-old without the parent being, or the parent's consent. So it's not just a consent to see, but also the consent to treat. And you wouldn't know what the treatment would be till after you're actually seeing the patient. Cassie, do you have thoughts on that one?
No, I think again, it's just making sure that that treatment is that the minor isn't consenting to their treatment specifically. That's where it gets a little tenuous.
Do you want to take a look at that question on
So
CPS?
CPS, so if CPS requests records and I didn't report to them and I don't know who did, do I release the records? CPS, if they are the guardians by the court of the minor child or minor patient, then they can have access to the records. I would definitely verify that they are who they say they are before providing the records. You do have a little bit of time to respond to that request, even if you didn't make the actual report to CPS that there was an issue of, an abuse or neglect. But yeah, they can have the right to see those records. But again, verify who they are. Typically, they can provide a badge number or something like that to you to confirm their identity.
If one parent gives written consent to allow another parent to bring the child to care, can the other parent revoke the consent in the case of divorced parents? I would say that in general, if there is not sole custody um, granted by the courts, then there's no need to have one parent give a written consent to allow the other parent to bring them, because by law, either parent can bring the child in for care and consent at the same time. So, uh, any thoughts, other thoughts about that, Cassie? Oh,
Oop, did I accidentally move something there for Kathy? Sorry.
oh, I'm sorry. Um, do you have any thoughts about a parent giving consent and then the other parent revoking the consent in the case
Um,
of divorced patient
right. I
parent?
mean, if the divorce decree allows for them to, assign or offer consent, then I think it may that be that you have to honor it. But if there's a non-parent that's on the list, can they revoke that at any time? If another parent isn't involved, then absolutely, I think that that's reasonable. I think this would be like a step parent situation, maybe, or a, a grandparent that is not maybe as involved or something along those lines. So if the court decrease removes the rights of that other parent, then yes.
How do you know if it's actually the parent or if the patient comes with a non-parent? I think the tricky part of this is, as Cassie just alluded to, when it comes to step parents that do not have consent necessary, or the right to consent to the treatment of the child, and again, that would need to fall back to getting permission to see and treat from the parent, that whether it's um, whichever parent it is. And I know that has to be a real sticky situation for practices, but it it is not something that you can just assume. Just talked about step parents. Any other thoughts
No,
on that, Cassie?
I think we've covered those. Yeah, someone is asking Kathy about portal access. I was actually going to ask you about this as well. Are there any concerns with access for the portal from a HIPAA perspective for parents, non-parents, um, for that information of the minor?
If if the portal is set up by one by the parent who is um, bringing the child in, you may have to navigate granting the other parent access. Because again, if there's not a limitation on who can access the information, then you just basically need to make that access available under the individual right to access your information. And that's, again, back to that old um, how they want to obtain the information.
So I know we've covered some of these questions here. Are a little bit the similar topics that we've covered as far as treatment and the minor, even if they're alone at the appointment, that they can't consent to their treatment, so that needs to be discussed with the parent. Um, One thing is, if there are divorced parents and there's not a certainty of who has what right, is it allowed for the practice to request that divorce decree to verify who can provide the consents?
That's absolutely allowable. And in fact, it's probably in your best interest,
Yeah.
because otherwise, if someone wants to know why you aren't allowing that access or why you are allowing that access, you have the documentation. And whoever you get it from, whichever parent you get that documentation from, a gentle reminder that if in the future this changes, please update us, because obviously divorce decrees or custodial decrees can be updated and change.
Yeah, and I know I've kind of hit on documentation, reiterate with divorced parents, and you know that you have those situations that can be a little tricky. Trying to manage those just with your discussions that you have with the parents when they are in the office, and that the documentation is really, really very detailed, particularly if only one parent is there. That way, if the other parent calls, then it can be clearly communicated and they can have all of the same information, not just assuming that, well, you gave it to one parent, it's going to actually get to the other parent. You're not required to call and give it to the other parent who's not at the appointment, but just ensuring that that documentation is very um, detailed to be able to relay the information equally to all of the individuals that are involved.
Right. I think that's great advice. Um,
So I know we talked a little bit about school systems, Kathy, and you mentioned about immunization. So what can be shared with schools or school nurses, or even is that a HIPAA issue or not an issue?
so if a parent has a copy of let's just say the immunization records. Um, Once it leaves the physician's office and goes to the parent, it's no longer protected by HIPAA because the parent is not a covered entity or a business associate. They are the parent of the child. And so they can basically share whatever they would like to share. However, it is um, it is certainly not um, it's not a HIPAA violation. So you have to use your best judgment as whether, what do you want to share with that patient. Obviously, it is a HIPAA document, or if you are asked to get a return to school and it says, may return to school, no gym for 3 weeks because of sprained ankle or whatever the situation, that is HIPAA information, again, until it leaves the office. Once it's in the parent's possession, then it's not covered under HIPAA.
So another question, Kathy, that kind of falls in line with that because we didn't want to overlook HIPAA today in our discussion is what about law enforcement if they're requesting something maybe in relationship to abuse or neglect or something along those lines? Would there need to be a subpoena in place or how would HIPAA apply in that situation?
Law enforcement there are some very specific HIPAA rules around law enforcement. And maybe that would be actually something to include in a future webinar, Cassie.
Hmm.
There is something called a blue sheet. It was actually developed with federal government and law enforcement that kind of outlines both for the practice, but also for law enforcement, what they can legally ask for and what they need a subpoena for, that type of thing. And so I would, you're certainly welcome to email us at cyber@tmlt.org, and we'll be happy to send that document to you, or you can email risk management. They also have access to that document. But it is very difficult um, to answer that broad question because different situations are going to be different. But it's very helpful to have this document so that you can physically hand it to the law enforcement officer that's standing there saying, I want these records. And you have backing of why you're saying, no, you can't have them.
So looking here, any other questions, Kathy, that I have overlooked that we haven't addressed yet?
Again, because so many of these are similar,
Mm-hmm.
um,
Think we've touched most of them.
right. And again, if you specifically have one that we didn't specifically address, you're welcome to send us an email, or you can always, uh, you know, put it in the suggestion for future webinar too,
Mm.
and we can take a look at that.
So one other question, Kathy, is revisiting how to identify. I think you were talking about identification, identifying the adult when the minor with the minor as their parent. What is allowed as far as verification of their identity? Tricky.
That one is very tricky. I guess I guess you can request to see like a driver's
Driver's
license to
license, right?
verify their name. Of course, that's not going to give you the relationship to the patient, and that may be one of those situations that um, you may it may be a difficult situation based on the presentation, but you may just have to say to the child, "Who is this that brought you in today?" But that may be an inflammatory statement for the adult too.
Yeah, and I'm wondering too if this, I mean, because this is a newer topic of late as far as being able to identify that it's not a trafficking situation. And if that is something that you're curious about, there are some really good resources and what Kathy mentioned about questions and how to engage the minor that are on the Texas Health Steps resource page. They have some good resources that kind of walk through some of these more sensitive conversations or dialogues to better identify who is with the patient and is it actually the parent that they're supposed to be with. So that might be a good resource for you if you're looking for some specifics and specific questions on how to navigate. um, and then they will also be able to that those I think those resources also can give you some guidance on which types of identification are appropriate to ask for. I mean, obviously driver's license, but if you're still concerned even after that that it's not the parent, having some additional tools and questions that you can ask to get to that um, to answer that you're looking for.
Uh, some of these are real case specific questions. Um, and I would say that if there is ever a situation, um, you know, Cassie and I are not attorneys, and we we do the best we can to bring you the best information out there as well as resources. But there are some of these very complex situations that you may want to speak with an attorney to see what their advice is.
Yeah, and I mean, we do apologize for not being able to answer some of those questions. They're just, again, not being attorneys. We don't want to lead you astray, and they can be very sensitive, and sometimes we don't know all of the details that are surrounding that particular situation, so it makes it a little bit of a challenge. And again, we don't want to give you the wrong information. So it looks like I think we've covered all the main topics that we can address today.
I think so. We're wrapping up the hour, and I would just want to thank you all for being so engaged. I know we knew this was a difficult topic. We know that lots of people have lots of questions, and so please, again, if you do have specific questions that you feel like were unanswered, either send us the question um, by email, and we'll do our best to point you in the right direction. Again, you'll get an email tomorrow with the recording as well as a link to the CME evaluation, and your CME certificates will be emailed to you within about 10 business days. Thanks, everyone, and we will see you again soon for the next webinar.
Thank you.